morning, everyone, and welcome to today's session where we'll be discussing the new lease code, as well as standard forms and looking at their place in a post-COVID, post-Brexit world. My name is Stephen Smith, and I'm delighted to be joined again by Mark Shelton. Mark is a freelance legal trainer and has 30 years experience in working in major law firms, commercial law firms. Good morning to you, Mark.
Good morning, Steve. Thank you for that introduction.
How have you been? How have you been in the few months since we've last spoken?
Keeping busy, and yeah, all very good.
I believe a house move in there as well. Is that correct?
Yes, that's right. But that adds a little interest to the months in lockdown.
Yeah. Indeed, absolutely. Anyway, just before I hand over to Mark for the main part of the presentation, I just want to let you know how you can all get involved today. So you are by default joined by your computer speaker system, but if you would like to join by the telephone, you can do so just by choosing the telephone option on your control panel. The dial-in information will be displayed, and I've been told that the reception over the phone is as good as it is over the speakers, and it is toll-free as well. You can ask questions at any point during today's session. There will be a designated Q&A at the end of the session, so we will tend to hold the questions right back to the end. But if you do have any questions you would like to ask during the presentation, please let us know. You can also raise your hand if you're having any IT issues, or if you would like to speak to us directly, we can unmute you and you can speak to Mark or myself over your microphone and speakers as well. There are also a copy of the notes for today's session in your control panel. So there should be a section called notes where you can download a PDF. So if you want to follow the presentation along with the notes, you're able to do that. Please do get in contact with me if you have any issues there. Anyway, without further ado, I'd like to pass over to Mark for the main part of today's session. So thank you, Mark.
Thank you, Steve, and good morning, everybody. So lease terms really is the topic of this session, and of course, you know, Steve referred to us being in a post-COVID, post-Brexit world. Short terms are very prevalent, and particularly with low value, low rent properties. If a lease is going to be granted for 3 years, 18 months, less, then there's not really much appetite for a 70-page commercial lease to govern the relationship, and certainly occupiers are unlikely to want to pay, sadly, the professional fees to have that kind of document produced. So this is where, you know, the lease code comes in. We have many occupiers who are unrepresented in their lease negotiations, and increasingly probably many landlords who are unrepresented in their lease negotiations as well. So the lease code is to really trying to upskill people to help them to navigate the world of commercial leasing. I'll talk about the lease code. It is, of course, in a new edition, as Steve mentioned, and we'll talk a little bit about what it contains, and then we'll talk a bit about how effective it is or is likely to be in doing the job of protecting the unrepresented landlord or tenant. And then we'll talk about the alternative approach, or at least a complementary approach of using standard lease forms instead. So first of all, the code, it is no longer a code. It is the RICS Professional Statement Code for Leasing Business Premises, which is really just putting it into the RICS Professional Conduct Framework. And of course, it principally consists of an updated, revised version of the familiar lease code. There's also an updated version of the accompanying template heads of terms. There's a new heads of terms checklist. That's if anybody wants to continue using their own familiar in-house heads of terms, they can check it against that checklist and make sure it contains the information required by the code. And the old code had something called an occupier's guide. Now we have instead a guide for landlords and tenants. So that's updated in a different document as well. So it's a little suite of documents. In your notes, there's the URL where you can find it on the RICS website, or you can just Google Code for Leasing Business Premises 2020, and you'll find it easily enough. Why make a song and dance about the code now? Well, it's really because it's set within the RICS professional conduct framework that members of the RICS, whether it's letting agents or landlords who are RICS members or registered firms, they're going to face potential disciplinary consequences for departing from the code, and therefore we can expect that there'll be much more of an expectation that solicitors will be negotiating code compliant terms. Now, the codes, or the professional statement, I should say, contains mandatory elements. They don't really concern us very much. They're essentially concerned with the provision of information as part of the negotiating process and the conduct of the negotiating process. They're going to be relevant to letting agents and landlords rather than solicitors. And in any event, they're not very extensive. There's only 5 mandatory points. Most of the code is non-mandatory, and it consists of good practice recommendations. Now, the professional statement recognises that RICS members may depart from these recommendations. They are recommendations, they're not mandatory, but it says they should only do so in exceptional circumstances, and they may be required to justify having done so. So, as I say, there'll be an expectation, I think, that solicitors will be producing code compliant terms. Now, it's a relatively lengthy document, the code, so we're not going to even attempt to plow all the way through it. What I'm going to do is pick out some selected main points of interest, starting with break options. And this is a familiar element of the previous code. The recommendation that break options should be conditional only upon there being no arrears of principal rent, i.e. not service charge, insurance premiums, fluctuating items like that, but the principal rent, the tenant giving up occupation, and the tenant leaving behind no subtenants or other occupiers. Specifically, the code goes out of its way to say disputes about the state of the premises or what's been left behind on the premises or taken away from the premises should be settled later, just as with any other normal lease expiry. They should not be a subject of a condition to the operation of the break. And this is all as per the old code. And of course, conditional break options have been very problematic for tenants historically. So these recommendations are great from a tenant's point of view. You can have your own view on them. I mean, I have a sort of feeling, or it seems to me that where a tenant is getting a valuable property right, the right to break the lease early, that it's not unfair for a landlord to expect in return to get the property back in a condition ready for reletting. And I don't think there's anything problematic about the principle of that. I think the problem is the rigidity with which the courts have interpreted those conditions. And a possible compromise might be a condition that the tenant should have materially or substantially complied with its repairing obligations, and that would prevent that sort of harsh outcome to a large extent. But that's just my view. That's not what the code says. I think in any event, post-COVID, the code is probably in this respect going to find itself lagging behind market practice because tenants had already become a lot smarter at resisting onerous break conditions and insisting upon breaks which they could actually operate. And we see more and more breaks, and they happen at more and more frequent intervals, even in short leases. Now, of course, none of this is welcome to landlords, but of course, it may actually be helpful where there are break opportunities in the lease. You can monitor those, you can liaise with the tenant and get a feeling for what they're thinking, rather than being caught out by a tenant insolvency or some serious default. So there's an advantage in it in management terms for landlords as well. And of course, tenants ought to be prepared to pay a little bit more for the flexibility, as long as it's reliable flexibility. Yes, there'll be an impact on the valuation of the landlord's interest, probably not as much as the impact of having a void unit. One other interesting point is the code goes on to recommend that leases should require landlords to repay any rent or service charge or insurance premium which the tenant has paid for a period after the break takes effect. Now, that's a new provision in this version of the code, and that reflects the difficulty that tenants can often face when they operate a break, that they might end up paying for a period when they don't have possession of the premises. Now, that's great. I think it might usefully have been extended to apply to all modes of lease termination, not just break options, with the possible exception of forfeiture. Because it may seem obvious that if a lease comes to an end on, let's say, 31st of July, that the final payment of rent due on the 24th of June should be apportioned. And in practice, tenants usually will pay an apportioned amount, and landlords will almost always accept that. Not unknown for landlords to attempt to recover a full quarter's rent. I've certainly come across that. And so a more general recommendation that leases shouldn't have the effect of requiring tenants to pay for any period for which they don't enjoy possession, I think might have been a preferable situation. But that's about break options. As to rent review and rent a bit more generally, well, this is a bit odd because the code, when it talks about rent review, focuses only on procedural matters. It doesn't deal with the basis of rent review. It doesn't deal with upward only rent review. It simply recommends that leases should allow each party to start the rent review process, which is fairly normal anyway. It also says that leases shouldn't have those sort of timetables of notice and counter notice that one used to see with strict consequences. So what it actually says is leases shouldn't impose time limits intended either to prevent a review or to set a new rent because of inaction by the other party. So all that is very much in accordance with present drafting practice. But as I say, the old code used to recommend that landlords should offer priced alternatives to upward only rent review, and that's dropped out of this version of the code. But again, I think in the market, tenants are increasingly looking for flexibility in leases, particularly as regards rent arrangements. And while many leases are too short now to incorporate rent review provisions, if you do come across them, then of course they usually normally still on an upward only basis. And if one thinks back to the late 80s, the early 90s, previous periods of recession, that's been extremely controversial. And indeed, pressure to legislate in relation to upward only rent review led to the first edition of the Lease Code in 1995 as a means of heading off legislation, which it succeeded in doing. So it's been very controversial in the past. I think it's likely to be so again. And this is something which may change as a result of the COVID-19 crisis. And if it doesn't, well, the government has promised a review of commercial landlord and tenant law. They're going to look at rental arrangements, and there may well be legislation. So we shall see. But one response to COVID-19 has been an increased willingness to enter into turnover-based rent arrangements, of course, most commonly found in retail, leisure, food and beverage leases, not unknown in other sectors too. But the attractions from the tenant side are pretty obvious. If you're in difficult economic circumstances, of course we are, then there's a downward adjustment of the property costs, and it insulates the tenant to a certain extent from the impact of that. Plus, you have a landlord who is very strongly incentivized to promote the retail centre, to keep it well managed, keep it well maintained, keep it fully let, because of course that maximizes the rental income. And there's always that incentive for landlords, but it's a much more direct relationship where rents are payable on a turnover basis. So that's what's in it for tenants. And we've seen, of course, the new look CVA, among others, over recent months, where over 400 stores have moved to a turnover basis. Now, the attraction to the landlord is a bit less obvious because, of course, they're taking on part of the tenant's business risk. But one shouldn't just focus on the downside. There's also the potential for the landlord to participate in profits and get a much better rental income than would otherwise be the case. And everyone has their own anecdotes about turnover rent arrangements, but anecdotally, there are occasions where they perform spectacularly, and landlords do much better than if they'd left on a rack rent open market basis. But more importantly, rather than the off chance of that, because the arrangement gives the tenant a bit of a helping hand in difficult circumstances, then of course it promotes the sustainability of the tenant's business, which is why landlords have been so willing in the past few months to agree to move to a turnover rent basis with tenants. It reduces the risk of insolvency, it reduces the risk of rental voids. So, traditional turnover-based leases have provided for the tenant to pay a base rent, which is typically, of course, 75 to 80% of open market value, plus then a top-up element, and it's that top-up element which is calculated upon turnover. But now, increasingly, we're seeing shorter, more flexible retail leases. Increasingly, we're seeing a use of turnover-only arrangements where there's no base rent and the rent is simply a percentage of turnover. For a tenant, it's the ultimate rental flexibility. For a landlord, it's a much bigger risk, but it may be regarded as being acceptable for short, low-value lettings where you've got tenants who've got a very simple business model. Now, the idea of calculating rent upon turnover, you can express, as I've just done, in about 8 words. It's very simply expressed, but providing for the detail of it in lease drafting is rather more complicated, and typically you're going to see a 12-15 page turnover schedule in the back of a lease which has rent calculated on that basis. And you've got to anticipate not only the calculation of the turnover and the calculation of the rent, but also lots of practical implications of moving away from a fixed rent. You've got to try to anticipate changes in trading circumstances, changes in trading practices. Operators in retail and leisure particularly are increasingly ingenious in coming up with new means of generating turnover, whether it's restaurants entering into home delivery arrangements with Uber Eats or Deliveroo or whatever. Retailers offering so-called experiential retailing, cookery classes, craft classes, escape rooms, boutique cinemas, all that kind of thing. All of that, of course, creates challenges when you're trying to assess the rent on a store's turnover. But challenging or not, complicated or not, it's increasingly popular and something we're going to see much more of. Also, and not confined to retail and leisure, people are increasingly looking at inclusive rents. The tenant pays a flat rate and the landlord bears the risk of fluctuations in the insurance costs, service provision costs, business rates, property maintenance. And we'll come back to that topic a little bit later on, but all of these things tenants are beginning to look at now. The code's authors, I think, it's a little unreasonable to expect them to have anticipated the impacts of COVID-19, but these are nevertheless existing trends. They've accelerated and intensified as a result of the pandemic. I think it's perhaps a little surprising that the code doesn't at least encourage parties to consider alternatives to the traditional rack rent lease and alternatives to upward-only rent review. But leaving that topic behind, we'll go on to talk about some aspects of alienation. And generally speaking, the code has a fairly relaxed view to restrictions on alienation. One thing that's new in here is the old code provided for provision of an ARGA upon assignment, an authorised guarantee agreement, only in circumstances where the proposed assignment would dilute the covenant strength. And the new code is a bit more landlord friendly than that. The new code says that leases should enable the landlord to require provision of an ARGA, plus a so-called GARGA, if applicable. For anyone not familiar with that term, a guarantee of an ARGA. So where the assigning tenant had a guarantor, they enter into an ARGA and their guarantor guarantees their obligations under the ARGA. So the code says the landlord, lease should enable the landlord to require provision of an ARGA, plus a GARGA, if that's applicable, and or a new guarantor and rent deposit. So lots and lots of availability of leasehold security, reflecting, I suggest, uncertain economic times. The only limitation to that is that the requirement should be reasonable in the circumstances of the proposed assignment, and that's pretty generally what leases are going to say anyway. The code also says, in relation to alienation, that corporate tenants should be allowed to share premises with other group companies, provided they don't create a formal subletting, and where appropriate, that retail leases should allow tenants to grant licenses of areas for use by concessions. And that's precisely the sort of flexibility that, in particular, retail tenants will be demanding. Much more freedom to share space with concessionaires or franchisees, perhaps cutting across restrictions in the use clause, gives retailers the ability to freshen up the offer, liven up the mix of occupiers. Now, greater flexibility as an aspiration, it's easy to talk about. Again, not necessarily so easy to provide for in drafting terms. Retailers may well want to go beyond sharing with group companies. They want to share with concessionaires and franchisees as well. Landlords are going to want to keep the ability to police their tenant mix policies. But there is that aspiration in there. Contrary to that, the code says it may be appropriate for short-term leases to have more restrictive alienation provisions, provided that they're reasonable. Well, what's a short-term lease? There's no attempt to define that in the lease code. As I said, we're in a period of time where we are routinely looking at leases for 3-4 years or less. So that may well mean that more restrictions on alienation will be regarded as being normal, and that I think is slightly at odds with tenant demands in the kind of uncertain economic climate that we're in, where tenants are likely to be looking for greater flexibility as to alienation, as well as ever shorter lease terms. And one area where that's a relevant consideration, which has slightly touched on it already, is change of use. The code recommends here that control over change of use should be no more restrictive than is necessary to protect the value of the landlord's interest as a general proposition. And as I say, it's an area that tenants are likely to be very interested in the post-coronavirus economy. There's all the experiential retailing business that we've already talked about, allowing concessionaires and franchisees into occupation. I mean, the kind of experiential side of things, it's something that, of course, online retail can't offer. That's the attraction of it. So that's increasingly valuable to bricks and mortar retail tenants. For landlords, tenants are probably pushing at an open door by and large, because although, yes, they're going to want to police their tenant mix policy, on the other hand, it allows tenants, if you're more flexible, to create a greater number of reasons for customers to visit a particular retail scheme. So, the code is kind of chiming with this really and encouraging flexibility. Of course, another development that the code's authors could not have foreseen is the overhaul of the use classes order. And this is part of the government's response to the decline of the high street in general, but also in particular the COVID-19 crisis. This set of very significant amendments to the Town and Country Planning Use Classes Order, which came into effect coincidentally upon the commencement date of the new code, 1st of September 2020. And these are changes which go beyond mere tinkering. We're quite used to government tinkering with the use classes order from time to time, but this is sweeping stuff. The overall aim being to encourage flexibility in property use, and particularly in town centres, but of course it's not restricted to town centres. But there's a number of changes. The most dramatic change, we'll confine ourselves to talking about this one really, it is a new and very broad Class E, and that covers commercial, business and service activities, and it includes retail, it includes restaurants, it includes offices, financial and professional services, indoor sports, medical uses, nursery uses, all kinds of things, with a kind of broad sweeper up provision at the end as well. Any other services which it is appropriate to provide in a commercial, business or service locality. So very, very broad, and local authorities who have based their policies and their assumptions upon the old use classes definitions are going to have to rethink this, because to a large degree their control over the mix of uses within a town centre is going to be reduced, and the control passes instead to landlords, and it's landlords who are going to control uses by means of lease covenants. So although the use classes order provides for lots of flexibility, in practice that may be unavailable in a lot of cases unless landlords are also going to be flexible. So that's an issue in relation to existing leases, but for landlords and tenants who are negotiating new leases, going to take a little bit of careful thought as to how you address the range of uses that are authorised by a lease. The impact of tightening the authorised uses under a lease, well, it not only impacts upon the mix of shopping, or the mix of use within shopping areas and business areas, it also impacts upon potentially rental valuation and capital valuation if you've got an over-restrictive use covenant. So something that's going to take a little bit of thought to work out where landlords are going to go in relation to that, I think. Turning to alterations, There's a similar kind of general provision in relation to alterations that control should be no more restrictive than required to protect the value of the landlord's interest. And then there's a bit more specific stuff. So more specifically, a lease of a whole building shouldn't normally restrict internal non-structural alterations, while a lease of premises within a multi-let building may do so. And alterations which adversely affect the character, value, structural stability and so forth of a building may be prohibited. All of that pretty much in accordance with normal practice. But I mean, this is another area where tenants are increasingly looking for a higher degree of flexibility and perhaps outstripping the recommendations of the code. For a number of reasons. One, to do with coming out of lockdown, where of course many occupiers have needed to alter their premises so they can comply with social distancing, they can comply with hygiene requirements. And retail tenants anyway are going to try to accommodate the kind of retail innovations we've talked about, the experiential retailing. If they've got sharing of occupation with concessionaires or franchisees, that may lead to alterations. And then there's considerations in relation to signage and advertising. Advertising has always been obviously a crucial part of retailing, but now it's got to respond to the social media age, and it has to be very responsive. You want to, get that campaign capturing the particular trend at the right time. So you've got tight lease controls on signage or public displays, then that can be very detrimental to a tenant's business interests. One other point about alterations is to do with reinstatement of tenants' alterations at lease end. And the old code had a provision that landlords should notify tenants of any reinstatement requirements at least 6 months before termination. Now, I always thought that was rather a long period, rather earlier before lease termination than landlords might favour. But there is simply no recommendation of that sort in this present issue of the code. It's simply dropped out. And I think that's a shame, because this is the kind of thing which can be very problematic for tenants. If a landlord throws in a reinstatement requirement right at the end of the term and it's too late for the tenant to do anything about it, the case law is not very clear. The case law is, at any rate, not very helpful towards tenants. And some sort of time limit, some sort of mechanism would be helpful. If any of you are familiar with the Model Commercial Lease suite of documents, you can find that online, modelcommerciallease.co.uk. There's a good mechanism in there which I think works very well, which is that 6 months before expiry, the tenant can serve on the landlord a notice setting out the alterations it's carried out and requiring the landlord to respond, giving details of which alterations it would like the tenant to reinstate. And then the tenant is only obliged to reinstate requirements which the landlord has notified in that way within a further 3-month time limit. That, I think, works very well. It would have been nice to see a recommendation to adopt some mechanism of that sort. Anyway, the code is silent on it. As to repair obligations, again, as in the old code, repair obligations, the code said, should be appropriate to the length of the term and the condition of the premises. They should be proportionate, in other words. I've already mentioned inclusive rents. We can see landlords keeping responsibility for repair under those sorts of arrangements. Again, practice perhaps to a certain extent running ahead of the code. And if you've got an inclusive rent arrangement, there's no service charge, there's no repair obligation on the tenant. It's the opposite, or the antithesis, or the negative image, if you like, of the clear lease. And it's a very unfamiliar sort of creature. Many landlords are just not going to be prepared to grant leases on that basis. But it's got to be circumstance dependent, I think. If you're thinking about premises within an aging shopping centre in what is become a poor location, then a landlord who wants to let premises is probably only going to be able to let them on a short term, and probably only subject to a schedule of condition. Trying to enforce repair liability at lease end is going to be problematic. And as regards services, if you've got a lease of, say, 3 years or shorter, and if in the course of that 3 years the premises need significant work to common parts, something major like replacing a lift or recovering the flat roof, something of that sort, a court may well take a fair bit of persuasion that the parties intended that a tenant with such a limited interest should be responsible to contribute to such a major cost. And there's case law on that, for example, Scottish Mutual and Jardine Public Relations from 1999, quite a well-known one. So, trying to enforce recovery of service expenditure or trying to enforce repair liability at lease end in these sorts of lettings, you're going to end up spending a lot of money on professional fees. At the end of the day, there may well be some financial settlement. Will the landlord spend it on repairing the property? Maybe, doesn't have to. And these sorts of structures very often don't operate very efficiently in relation to securing the maintenance and the repair of buildings. And you can avoid all that by simply leaving it at the landlord's discretion. The landlord repairs as much or as little as the landlord feels like repairing. So we'll come back to that as we talk about standard lease forms. But just to mention, I think, a couple of missed opportunities. The code says nothing whatsoever about the presence in retail leases of keep open covenants, the obligation to keep open for trade during normal trading hours. And of course, that's been problematic during lockdown. Tenants have been required to close. Generally speaking, landlords have accepted that without any great difficulty, but it's quite hard to enforce keep open covenants anyway on the basis of the present case law. So there's a good case for saying they don't really serve much useful purpose and they shouldn't feature in leases. And we'll talk shortly about the RICS small business retail lease, which notably has no keep open clause in it, and that is a retail specific lease, but not mentioned in the code at all. The code also has nothing to say about so-called Jarvis and Harris clauses, whereby, you're probably familiar with them, landlords, as long as they follow the correct procedure, they can enter the property, perform repairs or other work, and then recover the cost of that work from the tenant. That can be very harsh on tenants, potentially, and the reason for those clauses being in leases historically is to enable landlords to get around the restrictions imposed on the enforcement of repair obligations by the Leasehold Property Repairs Act 1938. Well, it might have been useful for the code to recommend, I think, that there shouldn't be any such provision in leases to which the 1938 Act doesn't apply. Principally, leases less than 7 years, which of course is an awful lot of leases these days. But again, the code says nothing about it. So that's kind of run through some of the principal recommendations of the code. I rather wonder, who will benefit from it, and the objective, it says, is to improve the quality and fairness of negotiations on lease terms. But for whom? Presumably you would say the novice tenant or the tenant who doesn't have professional advice. They're the people who stand to benefit most. And most solicitors, most agents will deal with prospective tenants from time to time who have no professional representation. Because a small business, particularly if they're starting up, they're very, very mindful of their expenditure. If you're going to engage both an agent and a solicitor to negotiate a new letting, well, you've probably got fees going into 4 figures, which is something of a luxury. And particularly so if you're talking about a short-term, low-value lease. So the code addresses that in a way. The code makes it one of the mandatory requirements that RICS members who are dealing with an unrepresented party are required to advise them of the existence of the code and also to recommend them to seek professional advice. Is that recommendation going to change minds? Well, it may depend upon the degree of emphasis and urgency with which it's expressed, but also how much money the tenant has at its disposal and how determined it is to save fees. Being advised of the existence of the code, well, all well and good, but why not make it a recommendation to supply the tenant or the prospective tenant with a copy of the code? Because otherwise they've got to try to find it online, which is not that easy, actually. It used to be easy enough to Google it. Now, if you're trying to find it on the RICS website, that's a pretty kind of sprawling sort of online presence. It's not so easy. So the tenant has to find it, first of all. And having found it, they're going to discover it's a 42-page document. Are they going to print it out? Well, possibly not, let alone read it. It's a pretty significant chunk of text. So there's a barrier. Now, as regards the nature of the code, once they have accessed it, the previous code had an explicit aim to ensure that parties to a lease have easy access to information explaining the commitments they're making in clear English. It was not a 42-page document, it was a 15-page document. It was pretty much in plain English, as far as you can expect in relation to a slightly technical topic. Well, there's no such explicit sort of aspiration in the present document, and it assumes a fair degree of familiarity with commercial leasing practice, it's fair to say. It uses expressions like way leaves or security of tenure, schedule of condition, things that are not going to be obvious to our small businessmen. The old code had some extra help in the form of the Occupier's Guide. That was an 8-page document. It was kind of divided up into chunks with tips, 37 of them, so a fair amount of information for the occupier to digest, but nevertheless reasonably digestible. What we have now instead is the guide for landlords and tenants. It's not 8 pages, it's 18 pages. It is not divided up handily into easily accessible little tips. It is 18 pages of dense text. As an encapsulation of commercial leasing practice, it's a pretty impressive thing, but it's not going to be the easiest thing for the unrepresented tenant, or indeed landlord. And as I say, it may well be landlords who are trying to do without legal representation in these kind of circumstances. You're marketing a property every 2 to 5 years. You don't necessarily want to pay a lot of professional fees on every occasion. And there are standard forms of lease, which we're going to come on to talk about. They're available for free online. People are beginning to use them increasingly. There is a technical limitation to the ability of non-lawyers to use standard forms of lease. Preparation of a lease by way of deed is a reserved legal activity under the Legal Services Act 2007, has to be carried out by a solicitor or a licensed conveyancer. If anybody else does so, it's actually a criminal offence. There's an exception in favour of in-house surveyors preparing leases solely for the use of their employer. There's no aspect of protection of the public in those circumstances. But the more general way of getting around this criminal offence and getting around this restriction in the Legal Services Act 2007 is to grant leases which are not required to be by way of deed. In other words, leases for less than 3 years, principally. So nothing to prevent landlords and letting agents preparing short-term leases using standard forms. And that's precisely that kind of context where standard forms are going to be a more attractive and more useful sort of outcome. Now, that doesn't mean there's no job for solicitors. Solicitors will still have a role in selecting a standard form which is acceptable, and also putting in place protocols for executing documents, going through the contracting out procedure, and so forth. So there's still work there for solicitors. Now, historically, people have been very resistant to the idea of prescribed forms of lease. And one wonders if that might change a little bit. People use standard documentation for construction contracts, for domestic conveyancing, for all sorts of other contexts. If we have a government which is serious about removing obstacles to business, well, it doesn't necessarily have to legislate for prescribed forms, but it could promote standard forms, at least for simple, low-value transactions. This may be the kind of thing that the government will think about in the next few months. And we've got, as I say, readily available free standard forms off the shelf, the British Property Federation's short-term commercial lease, the RICS small business retail lease, the Law Society's short-firm model commercial lease. I mean, there's plenty of others, but of course those are all promoted by established, respected professional bodies, so they've got good provenance, and you'd think they'd be ahead of the field. Of those three, and we'll talk about all three briefly, probably the one that's most useful for general commercial transactions is the British Property Federation document. But we'll just sort of look quickly at the other two. First of all, the RICS small business retail lease. There are no introductory notes to it. It's got a sort of form of heads of terms with it. Obviously you can see from the name what it's intended for, retail leases and also for small businesses. There is a short footnote which indicates it shouldn't be used for lettings longer than 5 years. So precisely the kind of letting that I've been talking about. You can use it for lettings of whole or part. It is very short. It only runs to 6 pages and it's in plain English. One drawback with it, a very practical point, is you can only download it as a PDF file. You can't download it as a Word document. So in practice, you can't very easily amend it. And the other two lease forms we'll talk about are available in Word as well. But under this form of lease, rent is to be paid monthly. That's something, of course, that people have largely shifted to over lockdown. There's no provision for rent review, as you'd expect for a short-term lease. The tenant is required to pay business rates, so it's not a wholly inclusive rent, but it is otherwise. The tenant does have a repair obligation, but really it's what you'd expect to find in a short-hold tenancy. In a short-hold tenancy, it's only an obligation to keep the property clean and tidy, and in no worse state of repair than at the date of the lease. And there may be a schedule of condition to give evidence of that. Contrary to the lease code, it's very restrictive of alterations. It does permit approved signage. It does permit internal shop fitting, as you might expect for a retail lease. But alienation, also very restricted. I mean, this is it's not necessarily contrary to the code, because the code anticipates that short-term leases may be more restrictive in this respect. But all it permits is an assignment of the whole with landlord's consent, not to be unreasonably withheld. Otherwise, no alienation at all, and there's no provision for group sharing. No keep open covenant, as I mentioned earlier on. There is no service charge payable. The landlord does have obligations, but they're not very extensive, as you might expect. Just keeping the rest of the building in a state of repair that won't interfere with the tenant's ability to trade. The landlord has an insurance obligation, but there's no insurance rent. The tenant does not reimburse the insurance premiums. Oddly enough, no provision for contracting out of the 1954 Act, which is a little bit surprising. You would expect that people may well want to contract it out, in which case, given that it's not a Word document, you're going to have to prepare a rider and staple it on, or have the agreement in a separate agreement. There's also a tenant's break option, and this goes beyond the recommendations of the code in that it is completely unconditional. There is no condition attaching to it whatsoever. So a fairly unfamiliar form of document, and going back to a rather more familiar form of document, we have the Law Society lease, and as long ago as 1994, the Law Society first published model forms of commercial lease. Nobody liked them very much, nobody used them very much. Most people thought they were way too generous to tenants, I'd agree. But in November 2017, the Law Society released revised versions. It's a short form model commercial lease. Possible to use these appropriately for longer terms, actually, lets of up to 10 years with one rent review, but also can be used for shorter lettings as well. And this is sector specific. This is not for retail, this is for office premises. But it's a much more familiar layout compared to the other two leases. The old tenant bias that you found in the old Law Society leases has gone. It's a much more balanced kind of document. And again, you can download it in Word format, so if you want to amend it, it's a little bit easier. It's longer than the other two standard forms. It's about 20 pages. And I think that reflects the fact that it's not really intended as a sign here document. It's more a template rather than a standard form, if you like to think of it in those sorts of terms. And it says on its face it's a template, and some tailoring is going to be necessary. So it's intended for use by solicitors. You can use it for whole or part, but there are separate forms available for lettings of whole and of part. It has options for either quarterly or monthly payment. It provides for the tenant to pay not only the main rent, but also insurance rent and service charge if it's a letting of part. So no element of inclusive rent. The tenant does have a conventional full repairing obligation, but there is a drafting option for limitation by reference to a schedule of condition. There's a conventional Jarvis and Harris clause. Given that you've got a full repairing obligation, that's more onerous for tenants than in the course of the other two forms. And this is much less restrictive in relation to alienation and alterations than the other two forms. It allows an assignment and underletting with the landlord's consent. It allows group sharing arrangements. There is provision for repayment of rent paid in advance for any period falling after the end of the lease. And that's following up on my comment, howsoever terminated, not restricted to break options, with the exception in the case of forfeit. Yeah. There's a drafting option there for contracting out, as you would expect, and there's a drafting option for a tenant's break, operable only at a fixed date, and there's some conditionality on that, but only in compliance with the lease code. And there's provision for rent review on an upward-only basis. So a much more conventional sort of document, but a short, user-friendly lease form that might be useful. But as I say, I think probably the most useful of the three is the British Property Federation short-term commercial lease. I've given you in your notes the URLs where you can access and download all of these documents for free. Now, this is not sector specific. It's designed for all types of property. It's designed for lettings of whole as well as lettings of part. The intention, it says, there's some introductory notes. It says the intention is it should be used for temporary lettings, meaning from a few months up to 2 or 3 years. The aim, it says, is to produce straightforward industry standard documentation in plain English as far as possible. And again, it's a 6-page document. There's some accompanying matter. There's 5 pages of introductory notes. There are 3 pages of contracting out documentation, but other than that, it's a 6-page lease. And as I said, you can download it in Word format, so if there are any required amendments, it's easy enough. As I was talking about in relation to inclusive rents a little bit earlier on, it's the opposite of the idea of the FRI lease. Certainly, it's not going to be regarded as being institutionally acceptable. The BPF say in their notes that they are confident that landlords will increasingly be willing to offer terms like this on a short-term letting, and that does seem to be being borne out in the present market. So what does it do? It provides for quarterly payment of rent. Clearly, that could be amended easily enough. It is the landlord and not the tenant who has the repair obligation. It's a limited one. It's just to keep the premises in tenantable condition, and even that can be further restricted by reference to a schedule of condition. Odd to see that benefiting the landlord rather than the tenant, but that's the way it is. The tenant just has an obligation to use the premises carefully and not damage them, fair wear and tear accepted. So all of that proportionate, very much in accordance with the idea of the lease code. There will be an obligation in the case of a lease of part for the landlord to provide services, and there's no service charge payable. But again, that's quite limited. It's the bare essentials of providing hot water, heating, lighting, a lift service, caretaking, porterage. As I say, no service charge payable. No obligation on either party to insure the property. But if the landlord does choose to insure, no provision for the tenant to reimburse any insurance premiums which the landlord may incur. And the landlord pays the business rents, the business rates. So a fully inclusive rent from a tenant's point of view. And that is, in accordance with the concept of the document. It sets out in the introductory notes. The idea, it says, is that the landlord should be in a position to use his knowledge and experience of the property to produce a package which, so far as possible, does not give rise to any unexpected costs to be paid by the tenant. All landlord's costs are to be included within the proposed rent, which will remain fixed for the period of the lease. So, no provision for rent review. Again, it's a short-term lease. You wouldn't expect it. The document is restrictive in relation to alterations. It has an absolute prohibition of all alterations of any sort, including signage. So that is totally contrary to the lease code. It's also very restrictive as to dealings with the property. No assignment, no subletting, no other dealing, the only exception being group sharing. Now, because it's a short-term lease, that's actually not contrary to any provision of the lease code. But I think the key to it is really that you've got a very favourable break option in what is a short-term commercial lease anyway. So if you want to escape your lease commitment, that's how you do it. Rather than assignment or subletting, you exercise the break and get out of the property. So, and that I think is common to the approach in the RICS document as well. You've got a pretty standard Jarvis and Harris clause. The landlord can enter, remedy breach of tenant's obligations. The tenant's obligations are so limited in relation to repair that it is largely going to be restricted to removal of tenants' alterations. So not really a big deal for tenants. There is provision for contracting out, and there is, as I said, a very favourable break. It's a mutual break option on 1 month's notice. There is no conditionality applying to it at all, so that goes beyond the recommendations of the lease code. It doesn't, though, require the landlord to repay any rent or service charge paid in advance, but you can get around that problem as tenant just by paying attention to the timing of the break, really, as and when you get around to operating it. So I think, terms like these, they're not going to be universally accepted. They're not going to be universally appropriate. But I think it's an approach to protecting unrepresented tenants in low-value transactions, which is complementary to the code's approach of trying to upskill occupiers by means of the code. And of course, for landlords, it's one way of restricting transaction costs. So something we may see more of, but that brings us to an end of the presentation. I hope that's been useful and interesting for you, and we have some time for questions, so so do please pile in.
Yes, thank you, Mark. Just as a reminder to everyone, you can submit questions now through the text panel, the questions panel in your control panel. So we'll leave that open for a couple of minutes. Mark, we do have a couple of questions in already. If you're happy for me to fire away, the
Yes, of course.
first question is from Robert McAnally. Robert says, Mark, when acting for a tenant, do you think there is any merit in including in the lease a general statement in the lease to the effect that, notwithstanding any other provisions of this lease, the parties agree that this lease will be construed and interpreted in accordance with the spirit and principles of the RICS lease code? And have you ever seen such a provision in a lease?
I have seen such provisions, and it may be helpful. I suppose it's going to be a marginal help, really, because of course when one comes to interpret the provisions of the lease, that's what you're looking at, and it's only really in the event of any ambiguity that kind of provision would kick in and would take you to the lease code to try to interpret it. But I mean, I can see that it's something a tenant might think worth having. I wouldn't have thought it's something worth falling out over, and equally probably not too difficult a thing for a landlord to concede.
Excellent, thank you. I take it from your response that you haven't really seen something like that before.
Oh no, I have, but not that often. But I have seen it, yeah.
Yeah, excellent. Thank you. And thank you, Robert, for that question. Sandeep asks, when a lease is being renewed, there is usually a provision that states all other terms as per the previous lease, save for modernisation. The question is, does modernisation mean as per the code, e.g. the renewal lease having provision for uninsured risks when the previous lease did not have this?
It's a really good and interesting point, that, because that's one point I didn't touch on as to what the professional statement says, and and this is one of the mandatory requirements actually for landlords and letting agents, is that a renewal lease should also be code compliant. That's what the recommendation is. Well, that's a mandatory requirement, but that is subject to the reproduction of terms of the old lease. And of course, what you expect to find on a lease renewal is a court will generally reproduce the terms of the old lease. And if you want to depart from the terms of the old lease, you've got to have a very good reason to persuade the court to do so. So it just may not be practicable on many occasions to take an old lease which was not compliant and turn it into a new code compliant lease. And of course, the professional statement can't override what the courts will do and what the law requires. That point about reasonable modernisation, and again, that's something which is referred to in this respect in the professional statement. I always find that quite a difficult topic, because people will ask you, "Oh, this is just reasonable modernisation, isn't it? We can get away with that, can't we?" I always find it a rather embarrassing question, because so far as I know, the phrase reasonable updating or reasonable modernisation has never passed a judge's lips in any lease renewal case. It's a convenient market convention, really, rather than a sort of term of legal art. Or any kind of legal principle. So it's quite hard to know what the scope of that is. But I think that point in relation to uninsured risks, that's the kind of thing one might be looking at. But equally, it might be the kind of thing which has enough of a commercial significance that a court would say, well, that's maybe not. It maybe goes a little bit beyond reasonable updating. But it's very hard to say, as I say, because there's no real legal cutting edge on that.
Yeah, perfect. Okay, thank you, Mark. And Sandeep, thank you for that question. We just have one or two more questions in. So 1 second, I've just lost my screen there. So a question again from Robert. Is the 2020 code mandatory for RICS members, and what happens if it is not followed?
It is mandatory for RICS members, or at least it contains mandatory elements. And the mandatory elements are often a little bit wishy-washy. I'd say there's only 5 of them anyway, but there's for example, the first one is to conduct negotiations in good faith and in a reasonable manner. Well, who's going to judge that? Everyone can have their own ideas as to whether negotiations have been conducted in good faith and in a reasonable manner. Probably, Donald Trump thinks he always conducts negotiations in good faith and in a reasonable manner. So, it's not a very suitable kind of requirement for a mandatory requirement, it seems to me. But they're not all like that. I mean, for example, it is a mandatory requirement to notify an unrepresented tenant of the existence of the code and recommend them to seek professional advice. So it's easy enough to say whether somebody's complied with that or not. I mean, the RICS is not set up as a kind of police force. They're not going to go and audit letting agencies and see whether they've complied or not. So one assumes enforcement will depend upon somebody complaining and getting in touch with the RICS and saying, look, this letting agent has ripped me off and they didn't comply with this lease code, which I only found out about afterwards. And in that case, I think one can expect that disciplinary action will be taken against letting agents. But I think it has to be a responsive, a reactive sort of arrangement rather than proactive.
Yeah, interesting. Okay, thank you, Mark, and thank you, Rob, for that question. The final question we have: if you have let a property with turnover rent, can you include click and collect revenue as part of the turnover?
Well, I mean, the calculation of how you assess turnover is probably another hour's subject, really. But I mean, certainly, from a landlord's point of view, the principle that you hope to achieve is that you reflect the benefit to the tenant of the premises. In other words, you try to include in the turnover any sale which has a sufficient connection to the property, and that would usually include click and collect kind of arrangements. I mean, the example that I always use if I'm doing a training session on turnover rents is this: if you have Auntie Mabel walks into Curry's and she buys a gift voucher for young nephew Wayne, and that's in store A. So there's some turnover generated in store A. Young Wayne then goes into store B to redeem his voucher and pick up his PlayStation 5 or whatever. There you've got the voucher redeemed in store B, so there's turnover generated in relation to store B. However, they don't actually have it in stock, and so the order is fulfilled from stock which is held in yet a third Curry's store, store C. So there's a sale which has a sufficient connection with store C. Now, which of those 3 stores turnover should the sale fall into? And the answer is probably, given normal turnover rent provisions, it probably falls into all 3, and there's just duplication, which may seem unfair, but it's not really, because an experienced multiple retailer like Curry's would know that there would be an element of duplication in the way that turnover rent arrangements would work, and they would take that into account in negotiating the kind of percentage of turnover which they would agree to pay. So it's just a matter of calculating the rent on each of those stores. But yeah, that's kind of long-winded way of saying, yeah, if there's a sale with a sufficient connection to the store, and that would include click and collect, yes, you would expect it to be incorporated in turnover. Yeah.
Yeah, perfect. Thank you. Thank you for that question. We're at 11:59. We have had a couple more questions, Mark. So what I'll do is I'll try and squeeze one more in, and then
Sure.
anyone that we don't get back to, I think we'll try and get back to after the webinar and follow up on that. So
that's fine.
A question from Azruth, I hope I have pronounced that right. When granting a new lease on a flat, a clause in the existing lease on the adjacent flat states, to ensure that every lease of the flats granted by the landlord for the original term of over 21 years is in substantially the same form as this lease and contain covenants substantially the same as the regulations. would granting the proposed tenant the rights to extend into their garden amount to being substantially different? Sorry, I'm not sure if I read that out correctly, but
Well, at the risk of being unhelpful, we were talking about the commercial lease code, which only applies to business lettings. So moving into kind of residential flats is
yeah.
a bit of a shift. I mean, by all means, if that question is submitted to me afterwards, I'll try to address it.
Yes, apologies. Sorry, I just read that as it came through. Sorry about that.
Oh,
Mark, but thank you, Ezra, for the question. We will try and respond to you outside of the webinar. I think we'll cut the Q&A off there. Apologies to anyone that we haven't responded to questions on. But that just leaves me to say thank you to Mark and thank you to everyone for attending today's webinar. If you have any other questions, please do contact Mark or myself. Following this webinar, you will receive an automated email from GoToWebinar. If you respond to that, that comes directly to me, so I can forward on any questions you may have or any feedback you may have on the webinar to Mark. Sorry, you'll also receive an email, a separate email from my colleague Robert Kelly. That will contain the notes and the slides for anyone that doesn't have those from today's session. And also, if you have any questions for myself or Robert, please respond by Robert there. Just on behalf of Stewart Title and Mark, I'd just like to thank everyone for attending today's session, and I wish you a good rest of your day. So thank you and goodbye.